Hello and good morning. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions. We are a national preliminary notice service based in South Florida. And today is a phenomenal webinar on, wait, what? I only have 40 days to send my notice to owner. So let's get started. So welcome to the webinar. If you have any questions, please use the lower right-hand section of the Go to Webinar box where it says questions, and we will be happy to answer any questions after the webinar. And do not include any names or your company names in the question box. So today's agenda is, what is a notice to owner, notice to contractor in the state of Florida? Who is required to send a notice to owner, notice to contractor in the state of Florida? What does 45 days mean? What does 40 days mean? What if the owner pays the GC before I send my notice to owner? And best business practices. So, what is a notice to owner, notice to contractor in the state of Florida? Very simply, a notice to owner secures your lien and or your bond claim rights in the event of non-payment. A lot of people know the term of notice to owner, but this might be new for some people that are listening to this webinar this morning, a notice to contractor. Well, it's a combined form. It's a notice to owner, notice to contractor, and the notice to contractor is actually for projects that are bonded. We have the statutory language in our forms for the state of Florida. So for who's required to send a notice to owner on private projects? If you are not contracted directly with the owner of the property, you must send a notice to owner to secure your lien rights. So if you are working directly for the general contractor, and despite the fact that everyone knows your name, or you have a huge truck on the property, if you are not contracted directly with the owner of the property, you must send a notice to owner. So if you're a general contractor and you're hired directly by the owner of the property, you are not required to send a notice to owner in the state of Florida. So here we have a chain of command for public projects. Public projects are a little bit different. If you are a subcontractor that's hired directly by the general contractor, you are not required for public projects to send a notice to owner. For public projects, if you are hired by a sub to the general contractor, you are in fact required to send a notice to owner. Think of it as working with the owner of the property. The owner knows who you are. On a public project that's bonded, the general contractor hired you directly. So if you're looking to get paid and the general contractor holds the bond, then you go after the general contractor's bond. So in the scenario that you're looking at here, you have the owner, or we could call that the city, hires a GC, which hires a sub, which hires you. In this situation, you would be required to send a notice to owner. Now, what we've all been waiting for, what does 45 days mean? Received, not sent. So a notice to owner needs to be received, not sent, by the 45th day from first furnishing labor or material to the project. And again, the key word is received. So what does 45 days mean? Count every day, including your weekends and legal holidays. So if you have a the 45th day is a Sunday, it will roll into a Monday. If a Monday is a legal holiday, it will roll into a Tuesday. So here's the exception to the 45-day rule. An exception is specially fabricated material. So if you're working on a special window that can only be installed into a specific residential or commercial property, the clock starts ticking as soon as you start fabricating the material. So what does this 40 days mean? Subcontractors or suppliers should send a notice to owner no later than the 40th day from first furnishing labor and/or materials. And most importantly, keep a mail log that is stamped by the United States Postal Service. So what's all this confusion between a 40-day and the 45th day? So the notice to owner needs to be received by the 45th day, unless you use the manifest the U.S. Postal Service has it stamped by the U.S. Postal Service. And the notice to owner needs to be stamped by the 40th day from first furnishing labor or material. So what happens if the owner or the general contractor doesn't receive the notice until the 48th day based on this? Well, that's the great news. That's why it's absolutely beyond essential to send your notice to owners by the 40th day. And the manifest is stamped by the U.S. Postal Service saying it was served by the 40th day, so you don't miss that 45th day deadline. That is why it is so essential. The 45 days again means you must have the notice to owner in their hands by the 45th day. So you'll never ever know that. So the best business practice here is to make sure that you send your notices by the 40th day and have the manifest stamped by the United States Postal Service. So, as I said several times a few seconds ago, by keeping a mail log, you don't have to worry if the owner and required recipients receive the NTO, otherwise known as notice to owner, on the 45th day, as long as the mail log was stamped by the 40th day from first furnishing labor and/or material, unless it is specially fabricated material. Then, of course, your clock starts ticking as soon as you start working on the product. Now, what if the owner pays the general contractor before you send your notice to owner? Now, this is a scenario that I have seen come up several times, and you have to be very, very, very careful. If you wait, you can actually lose your lien rights. If the owner pays the general contractor before you send your notice to owner, your notice to owner is received, and an owner's received a contractor's final affidavit, you can lose your lien rights. So you want to be very, very careful with sending your notices to owners timely. A lot of people wait last minute. A lot of people say, okay, well, let me send my notices. We have 30-day terms. I'm going to send my notices at day 35. Well, you could be caught in this unfortunate situation. So the best business practices are send your notices to owners as soon as you sign your contract. It is the best the best business practice to have. You know that you are within your 40 days. You do not have to worry about the concerns of, oh, did the owner receive it by the 45th day? So the best business practice is to send the notices to owners as soon as you sign your contract and not wait. Now, we have helped thousands of customers secure their lien and bond claim rights. If you have any other questions, now is a great time to go into your question box on the right-hand side, and I'd be happy to answer anything. Oh, and we have one right here. Okay. Bear with me 1 second. I'm having a little bit of a technical issue. I can't see this. Okay, that was just someone asking if they needed to do anything else. Are there any other questions regarding the notices to owners? Yes. If you have a question, please feel free to put it into that box. And if you're having any technical difficulties, please feel free to send me an email regarding your 40th day. And I think, okay. Well, we have some upcoming seminars and webinars. Our next seminar is in Boca Raton, which is right around the corner in October. And then we have another phenomenal webinar, My Lien Was Bonded Off, Now What? So you could register for those webinars at sunraynotice.com/education. And that is it on 40th day from first furnishing labor and or material. So if anyone has any questions, feel free to send me an email. You can address all your questions and or concerns either to me, Ariella, at sunraynotice.com or at alex@barthet.com. I hope everyone had a wonderful webinar, and I hope you have a sunny day. Thank you very much.